Mesdames et messieurs, chères étudiantes et étudiants, j'ai 5 minutes pour dire quelques mots d'accueil pour cette conférence que vous pourrez suivre en anglais ou en français grâce aux interprètes, mais que je me permets d'adresser en anglais puisque les experts interviendront en anglais principalement. Je me permets donc de passer à l'anglais directement. So I switch to English. Ladies and gentlemen, I have 5 minutes to start with the opening welcome to introduce the agenda and the experts. Before that, few words about the context of the conference. This conference is part of our conference cycle about digital challenges that aims to promote the dialogue with the academia and the society. Among the topics, we choose the most actual and urgent ones. The first conference was about what social links at the digital age. The second conference was about what environmental and carbon footprint of technologies. The third one is today about what control over our data. And the fourth will be in December about how to ensure democracy with this information. These conferences also enrich my new transversal course, Understanding Digital, Parlons Numérique, open to all students with the aim to build a community of responsible students and citizens, some of whom will take the floor and ask their questions to the experts in 45 minutes. This being said, let's move on to the today's conference, which aims to debate on the control over our data and what role for international Geneva, so both the individual, privacy, and the geopolitical dimensions of our data. Privacy, individual dimension, as the massive collection and use of our data trigger our fundamental rights, including our right to privacy, self-determination, and personal data protection. For instance, when our data are used sometimes even without our knowledge and reveal all aspects of our lives, from our behavior and preferences to our beliefs and health status. Then geopolitical dimension as a single data, as well as all other data, such as technical and metadata, become a strategic asset for the economy, so that data should be contemplated as a whole, materially as both personal data and technical data are considered as the strategic asset, and geographically as a strategic asset may fuel innovation and may be a subject for a digital policy of every country. So for both dimensions, we can count on leading experts, who I will introduce in a few minutes. Before that, a few words about the agenda. Instead of dedicated presentations, we choose a panel format, according to which I will distribute the floor with specific questions addressed to each expert. We will have then 2 parts of 45 minutes each, a first part of 45 minutes with expert speaking time, where dedicated questions will be asked to them, to the experts. A second part of 45 minutes with the public participation, where questions from the students of my transversal course and questions from the audience will be asked to the experts. Indeed, questions can be asked and even ranked remotely by anyone following the conference now via the digital tool Slido, appearing to the right of your screen. So I really encourage you to raise your own questions. Before inviting all experts to take seats on the podium for this first part of discussion, I'm happy to welcome Ms. Peggy Hicks for an introductory speech of 10 minutes to map challenges. Let me introduce her. Ms. Peggy Hicks is in a good position to map challenges as a leading policymaker. She is director and in charge at the Office of the UN High Commissioner for Human Rights. She's in charge of pressing issues, including human rights in the digital age. Before that, she also worked in the humanitarian field as a clinical professor of human rights at the University of Minnesota, as advocacy director of human rights at Human Rights Watch, and in charge of UN missions in Kosovo and Bosnia-Herzegovina. Last but not least, it's a privilege to welcome her, also knowing that her agenda must have been tight as her organization is now in charge of the Forum on Business and Human Rights, a UN-wide forum with panel discussions to promote also dialogue with all stakeholders, and which precisely took place now in these current days. So to me, it's already an achievement in itself to be here and to welcome Ms. Peggy Hicks. Many thanks for being here. You have the floor.
So much, Jean-Yves. It's a great pleasure to be here and to talk on a topic that is so relevant and so important in all of our lives, never more so than today. There's no doubt that data is playing and will play an ever-increasing role in advancing human progress. Data-driven tools are at the heart of medical research and diagnosis. Data is part of our toolbox for preventing climate disaster. Data makes business operations more efficient, and data may help humanitarian organizations in pinpointing where their interventions are most needed. No doubt, data is incredibly valuable. You probably remember the slogan from a few years ago that data was the new oil. In fact, that understates the matter. The reality is that while you can make a lot of money with data, data isn't like oil, just a market good. Data is deeply enmeshed in our social and economic fabric. It reflects who we are, what we do, whom we meet, how we make a living. This is the reason why societies and economies are increasingly centered on exploiting data and that they need to think more and deeper about how to respond to the challenges our data-centered societies face. After all, Big Oil never attempted to have a say in everything you were doing, from what you read to watch, to the clothes you buy, to which restaurants you go to, which insurance you pick, and will accept you. These challenges can be seen, in fact, as falling into 5 different areas or buckets, and I'll turn to each of them in turn. Starting first, and most prevalently on many people's minds, are questions of privacy. Privacy risks play a central role in our discussions around the implications and datification of our societies. Consideration of these risks is a decades-old problem, but today the stakes are much harder. We all know that any smartphone could outperform the supercomputers of several decades ago. Ever more, the powerful analytical tools are continuing to emerge. They organize vast amounts of seemingly uncorrelated data. They automate decision-making, cutting time and notably cost. They predict behavior and events at individual and at a societal level. Each new application and each performance leap comes with the threat of deeper intrusions, the revelation of more intimate information, and also the real danger of manipulation of people and parts of populations. We've recently seen this play out in practice around the data and contact tracing apps, for example, which have become ubiquitous in our societies, and the debates over whether the types of data being collected and how it was being protected were sufficient. But although we can clearly see these threats, societies, in fact, have been very slow in adapting. Most societies in the world do not currently have effective data protection regimes. Of course, we in Europe have seen a movement towards more effective data protection spearheaded by the GDPR and a modernized version of Convention 108. And there are also new data protection initiatives in other places, and it continues to grow. Within the United Nations, where I work, there's a growing process to implement a new UN data strategy. And as part of that, we're establishing a comprehensive data protection and privacy framework. But even where we have these data protection regimes and that they've been developed, there is much work yet to be done to get them right. Are the regulations carefully enough crafted to protect other rights, such as free expression, and to avoid stifling innovation? Are these regimes effective, truly, in protecting our data? And what can we do about collective privacy impacts, impacts where people are exposed not because of their individual characteristics, but because they belong to a particular group of people? The second set of challenges we face with regards to our data relate to equality and non-discrimination. How do we ensure equality and non-discrimination in a data-centered world? Of course, one big hope has been that the data itself will help us to combat discrimination. However, unfortunately, we see that the reality is often very different for a range of reasons. Data has been linked to discriminatory outcomes in a variety of ways. First, I'd identify data gaps. Many people are simply not covered in data sets. For example, older persons, poor people, migrants, and all those on the other side of the digital divide are often underrepresented in the data that's available. There also is discrimination through data-based applications. There are so many reports about how artificial intelligence has driven discrimination in areas like recruitment algorithms. There's an example at Amazon of gender-based discrimination, predictive tools that are being used in criminal justice systems where there are recidivism predictions in the US that have been shown to be biased against Black people. In education, where a failed UK attempt to assess grades of students during the pandemic, which systematically disadvantaged students from poor, often minority neighborhoods, and we could go on. The third area of potential problems for equality and discrimination relates to the implementing complex data-driven systems which may exclude and disadvantage people, including through lack of digital literacy, lack of access to the internet or devices, and the reallocation of resources to tech solutions that may undermine access to meaningful help that's actually needed, for example, by leading to funding cuts for social workers, and in user interfaces such as forms of welfare applications which may be designed in ways that are incomprehensible to the target group or prevent error corrections or introduce overly simplistic forms that do not reflect the wealth of human experience and skill. So there's a lot of potential problems and being introduced in terms of equality and discrimination in the field of data. The third area relates to democracy and rule of law, and one that I'm sure is on many of your minds as well. Obviously, data is an amazingly powerful tool to create transparency and predictability of government decisions, but we also see, again, many threats emerging. Data-driven decisions are often based on opaque algorithms which challenge our ability to have a transparent, justified basis for decisions and actions by our governments, and therefore to have real accountability for decision-making as a whole. Much in the focus as well recently has been data-driven political campaigns, including the use of micro-targeting in disinformation campaigns, a topic that will probably come up in the next session in December, I expect. There are also data-driven models, and are these data-driven models more well-suited, and do they actually advantage more authoritarian systems of government over democracies? Yuval Noah Harari has written about this subject, really questioning whether or not, in fact, our data-driven societies make it easier for dictatorships to succeed. So democracies need to work very hard to develop and present positive models of data-driven governance. A fourth challenge relates to the role of the private sector, and this is something that we deal with a lot, and in fact, the major forum that's going on right now that the professor mentioned relates to the role of business. We are asking a lot of questions right now, and they all relate really in many cases to the exercise of power. Technology is not neutral. It is shaped by those having economic, social, and political power. And one particular challenge we face in this context is the role of companies. This, of course, has been with us for a long time. Different sectors within our economy have always had outsized power. But when we look at the role that technology companies play today, who amongst us can question that the roles and the relevance of big companies is a major factor in shaping how our societies work? But the question is, do we have in place the appropriate checks and balances when we're asking companies to play these now very outsized roles that can shape our societies and democracies? And at the same time, I'd say on the reverse, when governments try to regulate, we have lots of questions about whether governments are really fit for purpose in terms of how they regulate in the fields of data and technology. So while we often look past the companies to governments and hope they'll solve the problem, there are probably issues on both sides. And finally, as challenges, I would stress the issue of cross-border data flows. This is an issue where, of course, the data that we're dealing with does transcend borders, and that means that we need solutions that transcend borders as well. We need to be able to look across ways that we use data and be able to ensure that there is rights protection built in particular for the rights to to privacy. And that's where, of course, we hope that the human rights framework that my office works on a day-to-day basis can be particularly helpful, given that it has already been ascribed to universally across the globe. A case study in this area relates to so-called data localization, the idea that data has to be kept where it is gathered. That can cut both ways. It can be a possible tool to safeguard people's rights when you look at, for example, the way that the GDPR requires adequate levels of data protection in third countries, so it helps us. But at the same time, we also know that data localization can be a tool that autocrats can use to exert control over digital space and crack down on dissent. So given those 5 big areas of challenges, which we could probably have a session on each, it's clear that the data governance solutions that we talk about later will also need to be multifaceted and complex. There's no easy way out of the issues that face us. I'd like to highlight 4 elements for future action in terms of the governance of data. The first is that we need international cooperation, and we need to look further and beyond the ways that it's currently being done. The Secretary General has a roadmap for digital cooperation, which has outlined what that digital cooperation could look like. Second, no matter which approach we undertake, we need multi-stakeholder and multidisciplinary actions. We need to break down silos and really not have a separate conversation about data in counterterrorism and data relating to health and data relating to business, but those conversations need to be connected. Third, we need for this to be a global conversation. Too many times these conversations are really founded here in Europe, across the Atlantic to the United States, but leave out the global south almost entirely. And to the extent that there is a conversation with China and with Asia, it's on 2 parallel tracks. And finally, from my perspective, we need to strengthen the application of human rights. We need to rejuvenate the way that we look at democracy and rule of law as part of these conversations. As I said, human rights, we believe, is an incredibly rich and adaptable framework that can provide us all with guidance on how to shape how we work with data and in a way that makes sure that it helps people and that ensures that everyone can benefit from the technological progress we are achieving. Now, I listened to a podcast where they tell us to worry about everything and panic about nothing. So I may already have created a bit of panic in walking through the areas of potential risk here. So I'd like to close by just saying a little bit of good news. There's a lot that's already happening in this space. The Human Rights Council of the United Nations, its special procedures who are experts on human rights, the Secretary General's actions that I spoke of earlier, the work that we're doing within our office, including an initiative directly facing towards the companies and their responsibilities. All of those things are directed to address some of these challenges. With regards to artificial intelligence, UNESCO, one of our partner organizations within the UN, is developing a new instrument on ethics. The Council of Europe is also developing a new instrument rooted in human rights. And there are many other developments, such as developments most recently in the EU, to curtail some of the worst abuses, for example, in surveillance technology, and updating the export control regime there, which we're glad to see. There are, as you all know, also a lot of revived and reinvigorated conversations around competition law and the way that it may have an impact on our ability to better regulate and control data. And of course, we are turning back full circle to the way that these technologies themselves can help us solve some of these problems. There are new forms of encryption and new ways of dealing with these standards in different approaches through technology itself that will help us, I hope, to address the challenges I've outlined. Thank you.
Thank you. Is it working? Yes. Thank you very much, Ms. Peggy Hicks. It was a perfect way to introduce mapping the challenges and also to set the scene for the discussions that we will have now. So I'm happy to invite all experts to come on stage for the discussion. And again, I invite all participants to ask their questions via the digital tool Slido to the right of your screen, so that few best-ranked questions will be selected later. Now let me introduce our experts. In addition to Ms. Peggy Hicks, we have a second expert, Professor Maya Hertig-Randall, who is Professor of Constitutional Law and Director of the Department of Public Law, also co-director of the Certificate of Advanced Studies in Human Rights, responsible for the Law Clinic on the Right of Vulnerable Persons, and member of the Swiss Federal Commission Against Racism and of the International Committee of the Red Cross. Third expert is Paul-Olivier Dehaye, a leading personal data expert, founder of Personal Data IO, and member of the board of My Data Global, two non-profit organizations working on personal data empowerment. A mathematician by education, he is engaged in strengthening the transparency of algorithm and making data protection individually and collectively actionable, for instance, through collective data access requests. His work has led him also to investigate and to be the whistleblower for Cambridge Analytica. Fourth expert is Mr. Jean-Yves Hart, who is remotely participating, Senior Director Strategic Partnership at Microsoft, in charge of the relationships with international organizations and the WEF. His expertise includes public policy, business and human rights, cybersecurity, and privacy. Fifth expert is Professor Dorothée Paumann-Poli, director of the new center, Geneva Center for Business and Human Rights, as well as research director at the NYU Stern Center for Business and Human Rights. Her expertise is at the intersection of business and human rights, including corporate responsibility, which has led her to work on the implementation of human rights in multi-stakeholder settings. Finally, we have a sixth expert, Professor Jacques de Vera, Professor of Law, of Obligations and Intellectual Property Law at the Faculty of Law, University of Geneva, Director of the Center for Digital Law. Recently, he was Vice Rector of the university in charge of the digital strategy, which led him to the adoption of our digital strategy. He also co-organizes the WIPO UNIG Summer School on IP and the Digital Law Summer School. So, it's a privilege to welcome all of you to be able to discuss with all these different expertise, because we know that data is a multifaceted question. You already, Ms. Peggy Hicks, well maps to what extent there are different dimensions. So to start the panel discussion, I suggest to structure the discussion in two parts. A first part will be dedicated to the individual and the human rights, the human dimension of our data, in particular human rights and our right to privacy. And a second part will be dedicated to the global or more geopolitical dimension of our data. So, if we start now with the first round of questions, and by the way, each one will be about 15 minutes. If we start with the first round of questions of 15 minutes that relates to the individual dimension of our data, as mentioned, in particular, human rights and our right to privacy, it's actually the main question to know how to strengthen our privacy and human rights effectively. We heard some initiatives, interesting works from different multi-stakeholders entities, but how to effectively strengthen the privacy. Here, just to start in the discussion, I just wanted to recall that while we know that our data are massively used to fight, for instance, against the pandemic, from mobility to health data, and when some of us do not use the Swiss COVID apps for privacy reasons, we tend to forget that our data are anyway massively used while using our smartphones or internet, even if we use social media. So for instance, Facebook uses our data for public health purposes, for instance, to predict our behavior following public sanitary measures, but also for commercial and other purposes. So that there is a massive data flows, we mentioned that previously, across countries, which questions the control over our data and enforcement of our privacy. So my first questions are addressed to Ms. Peggy Hicks already, and to Professor Maya Hertig-Randall, and aim to first map the concrete challenges that your organizations are facing, knowing that both of you are very involved in
an international organization. So my question is, how does digitization impact the work of the Office of the UN High Commissioner for Human Rights and the International Committee of the Red Cross regarding specifically privacy and human rights? And if possibly, can you also try to explain how do you see how to enforce human rights and privacy in the digital space?
Thank you very much for this question, and also I think the challenges were very well mapped in the introductory speech. So I will look at this question from the perspective of the ICRC, which is talking a lot about digitalization, and actually digital transformation is part of the ICRC strategy. Obviously not as an aim in itself. I mean, the ICRC is not here to promote digitalization, but because we can see, and that was also mentioned in the introductory statement, there can be positive use of, obviously, of data. If you have, for example, facial recognition, that can help, to find missing people. It can be helpful for family reunification. The ICRC also thinks of using technology. For example, when people are on the move, they might have to leave, without, and they risk losing their passports, their identity documents. So the idea would be that the ICRC could also offer a platform where people could upload their documents, become a trusted data manager. But obviously, as soon as you say trusted data manager, it's very important you are one and you are perceived as being one. So that then obviously also calls for a data protection, a robust data protection system, particularly as we work with vulnerable populations. And it was also well shown, I think, as you've explained it, data can also, if you don't respect people's privacies, you can then also infringe other fundamental rights, be it discrimination, access to housing, or when you have migrants, it can be persecution, etc. So you have to be extremely careful about protecting the data. So I think already looking just at the framework the ICRC set up, we have now an independent data protection commission, of which I am a member, not being an expert on data protection, but I'm starting to learn quite a bit about it. And what is also interesting is already you also have to do some convincing work within the organization. It is not necessarily obvious to everyone, why now all of a sudden the ICRC deals with data protection? What about, yes, we have rules, but how should they be interpreted? It might seem obvious to us, that they should be GDPR compatible, etc., but you have to do quite a lot of convincing, explaining, and also explaining that what I can also sometimes see is the risk that data protection can be viewed as a brake, as framing innovation. And the message our commission tries to pass, and I think has done so far relatively successfully, that we need to build data protection into innovation. It's not an opposition. If you don't do it from the outset, you will face problems later. Maybe to give you one concrete example. So the ICRC was adopted a biometric policy, which you can find online. And where does that come from? Partly, not only, but organizations, humanitarian organizations, face also increasing demands from donors in terms of transparency, accountability, tracing, that the food really reached the beneficiaries, and obviously fighting fraud. So some humanitarian agencies have used digital also, or biometrics, as for identification purposes. But obviously that is very sensitive data, and if you have it stored in a central database, for example, you have leaks or the data gets stolen, or you have data breaches, that could be extremely dangerous. So our commission also has an advisory function. We were involved in the discussion of this biometrics policy, and the solution which was found was to say we have to have a token-based approach. So there is no central database. It's a bit, if I understand correctly, like the Swiss COVID app, etc. But I think always to think as far as possible to build data protection, take it into account right from the beginning. And sometimes when things get urgent, it's not always obvious to take the COVID crisis. You need all of a sudden other means of communication, messaging. Well, what do you use? What is data protection compatible? And I think another challenge, you mentioned it, is the power of companies as well. who do you work with? You might also rely for certain solutions on a big company, one of the big technology company. You should negotiate contractual safeguards. It's not always so obvious to obtain them. So that's, I would say, a few challenges I can see within the ICRC. There are many more, obviously. Then it's the whole question, how does the ICRC itself deal with things like cyber warfare, etc., and all the... But I think already just to bear in mind that we have very vulnerable populations and that the stakes are extremely high, that the data, when we use data, that we cannot afford to have, not to have a robust protection system.
So I'll come in a bit from the perspective of the UN and the UN Human Rights Office on this issue. I mean, we too have to look at privacy and data from both sort of the internal perspective, what does it mean for our day-to-day operations, and then also how are we an advocate for how the rest of the world deals with data and privacy. On the internal side, for us, one of the greatest challenges is that, of course, we have data that is, as ICRC, is incredibly sensitive, and people's lives are in danger if it's not handled correctly. And in an environment where data breaches are what they are, where there are so many cyber threats and other things, we do look very seriously at what that responsibility means. And that's why we're very happy, as I mentioned, that the UN is really looking at a comprehensive data strategy and protection approach. And we're really, looking piece by piece at how we upgrade our system so that we're practicing what we preach. We're putting in place an approach to data protection within our own operations, which is one that we can model and live by and encourage others to adopt as well. But as I said, we also have that broader role on privacy and data. I mean, one of the things we emphasize is that the right to privacy is important in and of itself, but it's also a gateway right for other rights. Privacy is essential, for example, for freedom of expression and often of participation. People need privacy in many settings to be able to make an impact and be a human rights defender and for the safety of journalists and in other areas. So we need to make sure that the privacy issues are being addressed. So we've taken up these issues in a variety of contexts. We did a report soon after the Snowden situation where we wrote a major report on rights to privacy in the digital age. And we're actually doing another report this year that focuses on artificial intelligence and the right to privacy. And we did a report that was released earlier in the year, which was particularly current in that it focused on the use of, it focused on peaceful protests generally and technologies in peaceful protests, but also looked at things like use of facial recognition in the context of peaceful protests. So we're trying to take up some of those cutting-edge issues and bring the human rights framework in as an important tool that governments can use, and other actors, obviously, companies as well, in really applying their rights and responsibilities to protect rights in the context of the application of new technologies.
Thank you. So it's interesting to see existing rules and standards that you are building. We will come back to that with the second part on digital governance, to what extent there is a way to standardize or having a full harmonization. But maybe when Professor Maya Hertig was speaking about who do you work with, I turned to Professor Dorothee Paumann-Poli, knowing that she has also worked with multi-stakeholders settings. So my question would be to know how to promote both human rights and to strengthen trust between different stakeholders, and also knowing that there are many companies involved in the digitizations. And maybe I'm coming back to the question of Professor Maya Hertig. Who do you work with, and how do you build trust in this respect?
Thank you so much, and thanks for your kind introduction. It's a vast question, how can we rebuild or build trust? And coming from a business school context where we focus on the business models of companies, I first want to take a step back and remind everyone that the companies that collect massive amounts of data, the social media companies, have a very peculiar business model. They're essentially online ad companies because almost 90% of their revenue comes from online ads. So users provide data voluntarily, but it's the ads that make the money. And this is important to understand, coming back to building trust, because the way to make more money for those companies is to keep the attention of the users longer. The companies can do this in different ways. They can promote content that keeps the attention longer, and oftentimes this is extreme content or content that stirs an emotional reaction, that creates more friction. And so the algorithms actually push extreme content to the front because of that business model. The other way to make more money for those companies is targeted ads based on the data that the users have provided. And so the role of social media companies for data, it's important to understand that they're neither just vessels that put any content up that users provide, nor are they like newspapers, fully edited spaces. So it was Zuckerberg from Facebook who actually said himself, our role is sort of in between those two extremes, and to then create trust with the users, trust that has come under scrutiny, in particular around election times. In the context of the NYU Stern research, and I have to thank my colleague Paul Barrett, who leads this research stream, we've come to believe that they need to do 5 things. And so some of those 5 measures to rebuild trust respond to the challenges that Peggy outlined in the introduction. So first of all, we think that social media companies need to increase transparency. Transparency over content moderation. How does it work? How do the algorithms work? And also, how is it done by humans? It's great that we now have machine learning, and according to some companies, the algorithms can already flag over 90% of harmful content, but there are still humans involved for the rest. But how this system works is still rather obscure, and for users, key stakeholders, to have trust, there must be more transparency over content moderation. Second, we believe that companies need to enhance accountability. So we need to create mechanisms by which the tech companies are held responsible for the prevalence of harmful content. So it can't be that one company makes huge efforts to take down harmful content, others less, and we need to create such mechanisms to make sure that there are sanctions for companies that don't make sincere efforts to take down disinformation or harmful content. Coming to disinformation, we also think companies need to make a much greater effort to fight dis and misinformation. We've seen that in the US election context now, that this can work. So social media companies have taken down the hashtag #StopTheSteal in the context of the US elections, for example, and I think they generally have to be more aggressive to remove provably false content that threatens to undermine institutions, for example, free and fair elections. Fourth, we believe companies need to do better to improve fairness. We've heard from Peggy that there are inbuilt biases, for example, around facial recognition technology that make discriminatory issues much worse. And so Peggy mentioned the example of the predictive tools in the criminal justice system, which often have inbuilt discriminatory biases. These need to be removed, which requires engineers that are trained to understand the potential biases that they put in the systems, and also managers trained at business schools, this is where we sit, to understand that this is one dimension of decision-making processes and decisions that they take in this context. Finally, coming back to privacy, those companies, to restore trust, need to boost privacy. We need better protections against misuse of private data for commercial use. And Peggy mentioned that in the EU, we already have GDPR and Convention 108. So there are government regulations in place, I think, that do a better job than elsewhere. But overall, it's not just privacy and improving privacy that can restore trust. It also needs those other measures on all fronts, because as Peggy said, we can't silo them. And to achieve those 5 measures, I believe, coming back to Peggy's recommendation as well, we do need a global dialogue, we need an interdisciplinary dialogue, and a multi-stakeholder dialogue that takes into account the perspectives of governments globally, users globally, companies globally, because only then we can actually create feasible solutions. And I've seen this working in very different contexts. It's the multi-stakeholder approach that brings everyone to the table.
Thank you very much. I'm glad that you brought the notion of privacy, and that can be also a question of beyond. And that's why beyond privacy, there is a need for multi-stakeholders and a potential harmonization. And I'm glad that you brought that, because if we now stick to privacy, and I'm turning to Mr. Paul-Olivier Dehaye, he's a privacy expert, and also he has experience in the field, because you also made some access requests. So I just take the liberty to remind that you have interesting citizens initiatives in order to strengthen transparency, such as making data access requests from several companies via the journalistic survey Traquer son ombre, or together in the framework of my transversal course. I look forward to working together. And similarly, we hear that Uber drivers are doing now access requests. They are now taking legal action. Question is to you, Mr. Paul-Olivier Dehaye. How to get effective control over our personal data, and are recent data protection norms such as GDPR, because there are sanctions attached to it, sufficient to enforce our privacy and individual rights, including discriminatory effects? And if not, what should we have more?
So maybe my point of view will be a bit surprising, but I think a law like the GDPR can go a very long way to ensuring good protection of privacy and against discriminatory effects, like you were mentioning. On paper, it looks pretty good. There are a series of instruments like a data protection impact assessment, those transparency tools like subject access requests, all of those things that should guarantee to an individual, in theory, that they know what their data is used for, they are able to partition. So yes, data crosses silos when you look from the perspective of companies, but from the perspective of an individual, they want to make sure those silos exist. They want to maintain separate contexts for different activities. So in theory, all of this is in the GDPR, but in practice, it's a minefield to exercise your rights. It's totally non-existent. Some of those protections exist only on paper. In practice, they're not there at all. The enforcement is really the problematic point in my point of view, in my opinion. It's there is a law on paper, it's just not enforced at the moment.
But if we stick now to enforcement, so what is the gap you identified? Is it a local enforcement prosecution? Is it a local national regulations problem, or what is it?
Well, so the GDPR has this setup with several data protection authorities and collaboration mechanisms that are being explored, let's say, right now by different authorities. But the enforcement it's mostly lacking around transparency at the moment. If I ask any of you, where is your data? How is it used to take decisions? You might want to take a loan. What data came into that decision? You have no idea. For some people, it's just a big decision once in a while. For some others, it's like Uber drivers, it's decisions being taken every 10 minutes on their income, and that's their sole stream of income is dictated by an algorithm. They have absolutely no transparency on this. Companies on the other side resist the transparency with all the might they have, and data protection authorities sit on their hands, essentially.
But again, knowing that there are existing rules now with the GDPR and enforcement measures, what is it insufficient so far? Is it just the way they apply so far? Is it a lack of coordination? How did you identify some concrete problems?
It depends. It depends on the data protection authority. Some of them sometimes they don't understand, I think, the issues. There's a lack of skills or technical expertise. Sometimes they don't want to enforce. That's an allegation that I will make, and many others have made against the Irish Data Protection Authority with respect to Irish companies or companies established in Ireland. But it varies a lot, but but the result is there for individuals.
Could I add in one point?
Of course.
One thing I find interesting too, though, that we always stress is that, the GDPR is a model. And in so many of these areas, the way that Europe goes about regulating is going to be used and followed elsewhere. So if Europe gets it right, it can be very influential. But if it doesn't, the impact is also very profound globally.
And maybe leading to the discussion later, the GDPR has had already effects, influencing the law in California that was voted, and then the proposition that was just passed. And they are even exploring, so there's adequacy instruments to build bilateral, mimicry between laws. Mm-hmm. And they're even exploring the possibility to do such a bilateral an adequacy recognition towards the Californian law, so a state law rather than a national law. So yes, it's very much expanding. That's also why I focus in my answer on the GDPR, because it is driving the legal discussion worldwide.
Listening to you, actually, it reminds me how difficult it is to draw the line between the politic and the legal aspects, because GDPR is in place now, and sometimes, as you said, there is a lack of enforcement, but possibly because also not only lack of coordination, but also lack of willingness by some authorities, if I understand you. So maybe just a quick follow-up question to you, Mr. Paul-Olivier Dehaye. There is an ongoing discussion about data ownership, and I already see in the Slido that there is this question to know either data ownership or rather just strong control rights. My question is, should we shift towards clear data access mechanisms with strong enforcement, combined with our control rights, instead of the introduction of data ownership? Or do you think data ownership remains an interesting option?
Yeah, I don't believe in data ownership. It's too complex. There's a lot of data that is about multiple individuals. We might all have rights on this data, but ownership is too narrow of a notion to address this. I mean, who owns my shopping list? The fidelity card with the supermarket. Is it me? Is it my wife? Is it the couple? It's very unclear. And it turns out that there is a lot of data about that. If you think about COVID, we're exposed to each other right now. This is data about us being exposed to each other. It's about the pair of us. It's about me. It's about you. It's possibly about the room. This is personal data as well, but we can't just say it's mine and not yours. It's just not going to work.
Thank you very much. So I suggest that we already move to the second part. We all know that privacy is an immense topic. Now we move already to the general topic of digital governance, but we will come back to many ideas and suggestions you made, also harmonization or the conversion of the GDPR to international rules or other national regulations. And that's for the sake of time, because we also have the students waiting and, of course, our experts on Zoom. So the second round of questions, let's dedicate about 15 minutes, relates to digital governance. In particular, the challenges in the application of international rules to tackle digital privacy and human rights. Indeed, data, as mentioned before, is a strategic asset in the race of technologies, so that countries now adopt their own digital policies, in particular on data governance, sovereignty, or I think you spoke about localization, which may have concrete impact on local market players. As shown by many charts, we see that some regions have more impact, stronger market players. And also in terms of, at the national level, if we think of digital policies, some of them may be more protectionist, more proactive. In the EU, one can think of the recent EU data strategy. In Switzerland, one can think of the current Swiss Cloud study in order to reduce the dependency on market players abroad. But all these national policies will lead then to fragmentation. And fragmentation might be difficult also for questions of enforcement that we just spoke, while the questions are global, because privacy and data are across countries. So my first questions are addressed again to Ms. Peggy Higgs and Professor Maya Hertig-Randall before giving the floor to our experts on Zoom. But before that, to you, what are the gaps of existing international laws, also knowing that there are already international conventions in place that may possibly apply to our privacy, and what are the needs to develop new instruments?
This is a question we've gotten pretty used to answering, and I often struggle that our answer doesn't seem to satisfy everyone. But our approach has been that what we need to do is implement the law that we have. And in so doing, we may come across areas where we need to go deeper, dive, and expand some of the specifics that relate to novel issues that come up with technology. But there is so much we're not doing within the existing framework. It's really even hard to tell what those little lacuna may be until we get our act together and start applying the laws that are on the books. And we just had an example of that, of course. So, you know, our approach has been, let us use the frameworks that are there, let us exploit them to their maximum, and at the same time, let's start exploring, you know, areas where we may need to do more. But the reality is many of the ways that you would try to develop new international standards, and Maya, I'm sure we'll talk to this, it's a process, and that process itself can be very important in terms of really bringing people together around new standards. So it is an important process, but it's generally not a quick process. And unfortunately, many of these issues are issues that evolve over time, and where we need an approach that keeps pace with the technological challenges that we're facing as well.
I actually fully agree with you. I think also starting from the last thing you said, international standards, I think that is a big challenge, that treaties take so long to negotiate, and here we have a fast evolving environment, and you also have obviously different cultural and legal traditions. You need to find some common denominator. We know that sometimes the perspectives, even from the US, Europe can be quite different. To give an example, which is not now privacy, but take, for example, hate speech regulation, where in the Cybercrime Convention it was not possible to agree, so you have a protocol. So I think probably with at least universal instruments, that takes extremely long. And I also fully agree with you, particularly when you talk about human rights. I think a major problem is enforcement. It's sometimes said it's the least enforced, in a way, area, also because there's no reciprocal interest between states to make sure that these standards are applied by. And I thought very interesting what you said relating to the knowledge. I think I also, there's some echo, isn't there? No. I also run a clinical teaching program, and we always, the basic idea is that knowledge is also empowerment, and people need to know their rights, and we deal, with more vulnerable populations, migrants, detainees, etc. But I think when it comes to the digital sphere, that probably we're all vulnerable. I mean, basically no one has much of a clue. Some people do, maybe. I think Mr. Benamou might have a clue, but who has our data? What can be done with the data? And I think maybe we would also have to think that effective use of rights also means already, you could start in schools, also bringing the information down to the people, making sure that people even understand what is at stake. And you can also sometimes see contradictory, or what might seem contradictory reactions. A lot of concern about COVID app, but no one cares much about WhatsApp, etc. But I think without also making sure that this information is in a way transmitted, communicated, that there's trust. You mentioned trust. That seems to me important if you want to make progress.
Thank you. So maybe let's turn to Mr. Jean-Yves Hart and Professor Jacques de Vera to discuss the regulation, digital governance, and the possible role of International Geneva. Main question to both is how to strengthen Geneva as a hub for digital governance and possibly privacy. specifically to Mr. Jean-Yves Hart, my question would be what chances for an international legally binding instrument? So we know that there is a project such as the Geneva Digital Convention. And what are the benefits compared to existing international rules?
Thank you very much, Professor Benhamou. I hope that my answer is not going to disappoint you too much, because my answer is aligned with the one that Peggy Hicks and other members of your panel have just given. And that answer is that I think that there is already a lot of applicable legal rules in existing legal instruments to address many, if not all, of the challenges that Peggy Hicks was listing at the beginning of this session. Think, for instance, at the UN Charter, Article 2, Paragraph 1 of the UN Charter, which provides for the sovereign equality between states, and which is the basis for the principle of non-intervention in the internal and external affairs of states, and which could be the legal basis to address some of the issues around, misinformation about interference in the electoral processes of states, which is one of the issues and challenges that Peggy was mentioning at the beginning of her presentation on the protection of democracies. Think about Article 4 of the same UN Charter and the prohibition of the threat or use of force in international relations, which could be the basis for thinking, developing some new thoughts on the protection against cyber attacks, the protection of security of the users, individual users and organizations. Think about, we have already talked a lot about it, but think about the Universal Declaration of Human Rights and the two covenants that follow, which protect privacy, provide for decent jobs, that provide for, of course, freedom of speech. I mean, all of those provisions, all of those rules that exist already today, in my view, provide a potential for addressing or have a potential to address many of the challenges that we have been talking about. And I think that rather than trying to embark on the negotiation of a new legal instrument, the first thing that I think we could all do is step back and think about what the existing legal instruments mean in our era. What is it that the authors of those instruments, those that have signed them, those that have approved them, what is it that they were pursuing as a goal when they approved them? And how is it that we can pursue the same goal and achieve the same goal with the same legal instruments today in this new environment? Are there really major gaps that need to be addressed, or is it mainly a question of interpretation of those existing legal instruments and the Charter, the Universal Declaration, the fourth Geneva Convention, just to mention a few. Now, all those, all that work thinking about revisiting the existing legal instruments in the new environment in which we are, in my view, can take place here in Geneva, and it should take place in Geneva. It should first, because I don't think about any other city where it could take place. But it can take place and it should take place here because, to some extent, the international organizations that exist in Geneva are the guardians of those international instruments. The Office of the High Commissioner for the Universal Declaration, the RCRC for the Geneva Conventions. So you have here the base for and the guardians of those legal instruments that can oversee, manage, guide the interpretation, which I think is what we need before thinking about a new convention.
Thank you very much. Before giving the floor to Professor De Vera, quick follow-up question to you, Mr. Jean-Yves Hart, and also Professor Dorothee Baumann. How private companies can help shaping the rules, either soft law or legally binding instruments, while mitigating the risk that their interests prevail. So I'm turning to both of you. To what extent and how can we include private companies and being able to build together a balanced approach?
So I've done research on multi-stakeholder initiatives in other contexts than technologies, but I've seen that often it takes a precipitating event to bring everyone to the table, sometimes a tragedy that really makes every different type of stakeholder realize that only a common solution can be a real solution. So in the technology space, and I'm not an insider to this, but on paper it looks like the Christchurch Call, a multi-stakeholder platform that was created after the attacks on Muslims in New Zealand and initiated by the government of New Zealand and France, seems to be such an initiative where a precipitating event then drove the creation of a multi-stakeholder initiative, and that is seeking for joint solutions to religious extremism and attacks that from an online space translate to attacks on synagogues and mosques around the world. So the idea to bring those stakeholders to the table ensures that every single stakeholder has ownership in the outcome. And I think this is advantageous compared to regulation top-down from a government. A government can never be fully briefed on the very fast-developing tech space. So it needs the companies to make everyone else to understand what's really going on and how things work. If everyone has ownership in what comes out of this, I think it's a lot more likely that once there's a consensus over rules, these are actually implemented. We've heard multiple times tonight that it's not a question of a lack of high-level rules. It's often a question of actual implementation. And so rules that are made in a multi-stakeholder setting, I think, have much better chances to actually then being implemented once they're in place.
Mr. Paul-Olivier Dehaye. Oh, Mr. Jean-Yves, please, and then Mr. Paul-Olivier Dehaye. Yes?
Yes, well, I wanted to say that I fully concur with what has just been said. I think that there is, just as much as I think that Geneva is the place where the thinking on the existing rules, their scope, how they can be interpreted to cover the challenges that Peggy was highlighting at the beginning, all this should take place here in Geneva in the same way and with the same strength. I believe that it must be a multi-stakeholder discussion, which involves international organization, governments, businesses, and civil society. And to some extent, the fact that civil society must be part of the discussion is also a good reason to have those discussions here in Geneva, when you see the number of NGOs that we have at this city. I think it needs to be a multi-stakeholder discussion. There are already examples of those multi-stakeholder discussions and what they lead to. The Christchurch Call has been just mentioned about harmful content on the web, in that case, terrorist content. Paris Call on trust and security in cyberspace is another example of a great example of multi-stakeholder achievement. If you look at something which is closer to Geneva, it is the UN Roadmap on Digital Cooperation, where you have a number of recommendations which are implemented, also a multi-stakeholder way, by combinations of agencies, states, private companies, and civil society organizations. So I think that this multi-stakeholder way of addressing the governance issues which digital technologies are raising is something which has already been tested and which is working well. Frankly, I think that given the technology, given the difficulties which those technologies can be raising simply from an engineering perspective, also current technologies, but also what the future technologies are going to be, where is it that the tech companies are going? So these two elements, the complexity of the technologies, the views on the future of the technologies, where they will go, I think these two elements justify that you bring tech companies into the discussion with one proviso, which I would really like to emphasize. Tech companies do not claim any desire to make the decision. The decisions need to be made by governments. Interpretation needs to be made by the guardians of the treaties. Companies can contribute to the interpretation, can bring their knowledge, can bring the experience, can bring the vision of where the technology is going. But the decision at the end of the day need to be made by the governments, because that's also how the way to respect democracy. So I think it's very important for me to insist on this. And the role that the companies can play to help in the interpretation of existing legal instruments, but recognizing at the end that companies need to step back and let governments, countries, member states make the decision.
So I want to jump in because I heard something that I don't like. I heard a lot of things that I like, but the fact that yes, technology moves fast, that's for sure true, but do companies really need to be the ones explaining to governments how things work? I would contest that. I think that for the Christchurch School, for instance, where this person started shooting people and filming it and showing it on social media, it was most definitely not Facebook that was explaining to different global actors how their platform was used. It was actually a lot of civil society actors that were explaining that there was a problem there, explaining to governments why action needed to be taken, that they were documenting all of this, while Facebook was taking down the content, was taking down all the posts, in a sense taking down the evidence, while all of those civil society actors were trying to keep the evidence to pin down responsibility for parts of it. So I think that that is a crucial element, and it goes back to this transparency, but also to the fact that there are a lot of existing instruments that ought to be there to regulate all of those technological actors. But making the link between the existing instrument and the digital, there's a lot of people who have experience who can do that, and we can do it fast. But what is missing is the transparency.
Thank you. I suggest that we move also to Professor De Vera, because we are speaking about multi-stakeholder initiatives, projects, discussions. We spoke about fragmentation, and I'm wondering whether there is also already a fragmentation in Geneva with all the different projects. So my question is to Professor De Vera would be, what pillar should we focus on when we speak about possible regulations or solutions, i.e. should we focus on governance, on cybersecurity or personal data? And should we focus on substantial law, for instance, with high-level principles or specific detailed provisions, or rather on governance, for instance, with alternative dispute resolution mechanisms in order to increase the access to justice?
Thank you very much, Yaniv, and a pleasure to be on this panel. I know it's running late, so I won't be too long. I think it's important from my perspective to take a step back somehow to realize that when we talk about data and governance of data, we should not only focus on the issue of control of our own data by private companies and by big tech, because there are plenty of other ways how we can and should assess data governance. We referred early to the issue of COVID tracing application, for instance, which are another example of potential access by governmental bodies of our own data. We as citizens may also want to have access to governmental data. Private companies between themselves in a business-to-business context may also want to have data. So my point is simply to realize that there are plenty of ways to look at this issue of data governance beyond that of control by big tech over our own data. Now to the point as to what might be done, I think as reflected by what previous speakers have just mentioned, both Jean-Yves Hart and Dorothee Bowman, in saying that what is of relevance is a cooperation between the public and the private, and I fully agree with that. And to me, the question is also to think conceptually what could be proper digital rules today and tomorrow. And we should somehow move away from classical regulatory instruments such as international treaties, such as hard law instruments, and have a more innovative way of looking at things. And coming to your question, Yaniv, I think it certainly counts to have also an adopted transversal approach in the sense that we should not only look at a given issue, say cybersecurity, in a fragmented manner, not only from a geographical perspective, but also from a systemic perspective, but rather adopt a holistic approach by which we would talk about both substantive elements as well as procedural elements to make sure that whatever come out of these discussions between the private sector, the public entities, but also civil society, of course, academia, that may lead to really enforceable action and make sure that whatever is taken in terms of effective steps can potentially be enforced. And one final point also to confirm that I firmly believe that we have a card to play here in Geneva and in Switzerland. We have many global actors here, and we really should work on that as reflected, as you know, in the Swiss digital federal policy that was recently issued by the government.
Thank you very much, Jack. A quick follow-up question to you, and then we can move to the students. So you speak about a holistic, transversal approach. You also spoke about a more flexible approach. And actually, there is a Slido question about that, because someone is wondering how to have an effective regulation when digital technologies are evolving so quickly. And I guess that's probably what you suggested with a flexible approach, but how do you do that concretely? Do you have some suggestions?
I think one way to do it is to bring the relevant stakeholders to the table and somehow make it possible to adopt codes of conduct, which would most probably be easier to be adopted, which would somehow rely, and I think it's an important point, on the key expertise of the tech industry, because, and that goes back to what was mentioned earlier by Peggy Higg, we ask whether, a fair question, whether governments are fit for purpose to regulate technology. They may not necessarily be fit for purpose unless they are somehow like instructed to some extent or given insight as to how the technology works and can evolve. And that relies also from that perspective on the close interaction between the public sector and the private sectors in some kind of a public-private partnership.
Thank you very much. So let's move on now to the second part of the conference. I know we are a bit out of time, but we'll dedicate 10 minutes with the students' questions, and then we'll have we can take a few questions from Slido. Can we see our two representatives of the lecture on Zoom as well, so that they can ask their questions to our experts? Welcome. So Mr. Richards Kevin and Ms. Miranda Montero, please, you have the floor. Please address also your questions to specific experts if possible.
Good evening, everybody. I'm Kevin Richards, studying at this course in the Faculty of Society. We had some follow-up questions. We're wondering what type of institutions would be the best to manage and control the data? Would it be existential international organizations, or would it be better to create new ones? And at which level would it be the best to do so? Addressed to whoever would like to answer.
Mr. Richards, I suggest that you also, if possible, address the questions to some of the experts, and then also if we already can hear the other questions so that we can be able to answer all of them.
I will ask the second question whilst I'm thinking. And what would be the or how could we encourage the private sector to be more transparent and responsible regarding the usage of personal data? I would address that question to Mr. Art and to Mr. De Vera.
Thank you. So I guess the first question of which type of organization, existing or new one, is addressed to Open. It's open, so we open the floor for this first question.
Well, I think there are institutions that exist that can play crucial roles, but it's a varied landscape, and I do think there's a compelling need for more. And I think the answer that I was pointing to you, because I think your answer earlier showed the extent to which some of the existing institutions may not be, fully either able or willing to take on some of the challenges that we face. But I think that applies across some of these issues across the tech sector as well. We've looked at issues about how artificial intelligence is governed generally, and the types of issues that arise there, and the need for technological bodies within governments that have the expertise. And I don't think there's really as much disagreement as there sounded before. I mean, I think the reality is we need to bring more expertise into government, clearly, and we also need to draw from expertise wherever it exists to help make these processes more effective. But they need to be independent institutions, clearly. So we look more at what types of criteria we need for the institutions to be effective, and they need to be well-resourced, they need to be independent, but there do need to be linkages, because one of the things that was just raised that I think is so crucial is that it won't work if we start regulating in a way where we have disparate standards across all of these different ecosystems in different ways. It will be very difficult for us to govern something which is transborder with approaches that are very targeted in some cases. Now, of course, you have to adapt, but we really do need to look at ways that we can look across sectors and make sure that we're consistent and coherent in the types of approaches that are being taken as well. And I really appreciated the comment that was made about the extent to which we can do what's called co-regulation, which is, we don't look just at the companies to do it or at the governments to do it, but what type of codes of conduct, how can we put in place binding approaches that would allow and push the companies to do things that could be enforced even within a company-based system. And so that's something like this idea of social media councils that the former Special Rapporteur on freedom of expression has put forward, where rather than have each company setting how they're going to regulate for hate speech, for example, having standards that they all agree to and they all enforce together, and that they are actually enforced and binding upon all of them. An example of how that's been done in other industries is within the journalism setting, where there are standards that have been used, or in the motion picture industry, where companies came together to agree what they could put on and how they would regulate themselves. So we need all of those levels, I think, to address the problems that we face.
Let me just include a quick follow-up question from Slido, because it relates to that. Someone is asking, what could a citizen concretely do today to support better data governance? So I guess also to be included in the regulations and all these data governance mechanisms. Maybe Paul-Olivier Dehaye, do you have any idea or suggestions?
Well, so they should. The advice I was giving in Heidi in this interview was to join local groups that care about this, because I think being able to form some form of collective power in person is also very important, to be heard, basically, to show your political strength locally and then progressively at bigger levels. So that's what we're trying to do with My Data, not necessarily as a political movement, but as a group of people who want to change things, who want to make things better. And echoing this call for codes of conduct, actually, I think we're making good progress there. Talking to companies, so in the GDPR, in Article 40, there is a provision saying that companies can get together and can build codes of conduct. So the legislator has already anticipated that sometimes companies are better placed to do things, to do their self-regulation. And one of the points is codes of conduct for the rights of individuals, how they will exercise their rights. So I think that's a very concrete place where companies can get together, initiate a code of conduct, talking to a bunch of individuals who get together and decide on how these rights should be really exercised. And this is a meeting point where indeed the companies can decide on a set of rules that would be legally enforceable more directly than with the current avenues.
That's great. Already 2 concrete projects and 2 concrete actions. Thanks. You had the second question, addressed to Mr. Jean-Yves Hart and Professor De Vera.
Yes, so the question is how to encourage private sector companies to be more transparent with private data. So it is a very, very interesting question because it goes to something which I think is in the pipeline. We've seen the first generation of privacy rules. We are now at the second generation of privacy rules. GDPR is probably one of the best examples of this second generation of privacy rules. And those privacy rules and regulations are structured in all the same way. You're giving rights to individuals. The way I see it is that I think we are, and we will soon see a third generation of privacy rules that rather than giving rights to individuals, will put obligations on companies to be clear, transparent about what they do with individuals' data. GDPR is a really great privacy instrument. It's major progress, but it is difficult to manage. I think we all face the same challenges in really exercising the rights which are given to us as citizens under GDPR. I do face those challenges as well, and I do face them almost every day. So I think that we need to think more about this, what I was calling and terming as the third generation of privacy rules, which are going to impose rather than rights on individuals, impose duty on companies to be transparent in a way which is intelligible to the average user about what they do with their data, in particular data sharing agreements which they may have with other companies.
Any other comment from the experts? Professor De Vera or anyone else? So if it's not the case, maybe Ms. Miranda Montero, if you have one question, apologize, but we do not have much time, more time than for one question.
Okay. So, thank you for the question. So I have one question.
Yes.
So we know that China has created his own GAFA, and the US also have theirs, and the Europe is more focusing on the regulation. And so my question is, maybe can we say today that the GDPR allows to limit the manipulative phenomena such as fake news and targeted advertising on users? And so maybe should we redefine maybe data ethics and maybe think about doing a law specific to the digital? This is the question that I have, and maybe it is addressed to Paul Olivier Dehaye or Mrs. Peggy Hicks.
Should she repeat? Yes, that's the limit of digitization. You see, we don't hear you that well. So can you try to repeat and shorten the question so that maybe we catch the question? The mic is not very clear.
So the question is the GDPR allows the manipulated phenomena that we can encounter, such as fake news and targeted advertising and on users? This is the question.
I'm missing the verb. And GDPR, yes, but I'm missing the verb and the link. Sorry. Did anyone catch?
Is your question to know whether GDPR is sufficient to fight against fake news and disinformation? Is that the question?
Exactly, yes.
Thank you. Sorry for not understanding before. So I don't know that it's sufficient. I think it can do quite a bit, and I'll be very concrete. So in 2016, I asked Facebook for some of my data about me. So which custom audiences I was placed in, so which groups, which audiences had been built, and how it was used to target me. And I asked Facebook, it was a long process. Eventually I got some information. I testified in front of the UK Parliament about that. In follow-up questions, in questions just a few months later, to Mark Zuckerberg from the US Congress, he was asked if Facebook was fully transparent. He said yes. And then in follow-up questions by Senator Blumenthal, he explicitly referred to my own testimony in the UK Parliament, saying essentially, well, this guy is claiming the opposite. So how do you reconcile the two? So I was doing all of this to try to follow exactly the path that data would follow to target information to me. And I think that is actually quite important, not necessarily in understanding what is true and what is false, right, to understand the content, but to understand how the content travels and how it's amplified, which is the crucial role that the platforms play in this whole game. Now, I fully know that this is completely unrealistic for the general public to do, and for most people, even for myself, it's completely unrealistic to do at scale. But the point of doing it is to show really the mechanisms through which information is targeted and through which you can inject money or effort to try to shape the ecosystem, the information ecosystem around people. And I think that is some rights that the GDPR gives, and the GDPR gives even other rights. I could take this data and I could give it to a nonprofit that is trying to investigate disinformation. I could give it to academics, to all kinds of actors, to try to build collective sense of this ecosystem. And this is all imaginary, because right now, again, the law is not enforced. It's just impossible to do those things. It takes too much effort. So a short answer to your question is, on paper, yes, it could address a lot about those problems. In reality, we're very far from it.
Thank you very much. So speaking about disinformation allows me to take one slide of question. Thanks for your question. We will see at the lecture and pursue these questions during the semester. Thanks for being here. So if I take the slide of questions and back to the disinformation tackling this challenge, GDPR or other provisions, someone is asking, under what legal framework can social media be made more accountable and to fight disinformation? We just said GDPR or not. And someone is asking particularly with the First Amendment of freedom of expression, excuse me. If I can turn to all the experts, or specifically to Professor Maya Hertig.
Maybe just starting with the First Amendment, I think clearly freedom of expression is extremely strongly protected in the United States. And the basic idea is, which we always find in the case law, is the free marketplace of ideas. So the idea is the remedy is more speech, not enforced silence. Let the free marketplace sort out what is true, what is false. So if you follow this approach, then you will obviously be extremely skeptical to start regulating, fake news. There will be a lot of skepticism. Who decides what is true, what is false, etc. Then obviously nowadays this metaphor of the free marketplace of ideas doesn't work so well because, markets can also sometimes not function properly. You might have market failures, market distortions, and certainly one distortion is what was mentioned earlier, that extremist speech, etc., because it is linked to advertising, might get amplified. And I think, I'm not sure whether it's correct or whether I remember the figure correctly, but I think fake news travels 6 times faster than real information. Then you have also the difficulty that people have their biases and you interpret information according to also your existing biases. So when it is targeted to you, I think COVID shows it quite nicely that you have some people just caught in certain information cycles and conspiracy theories, and it's very hard to get to them. So I would say certainly if you stick to the very traditional idea of a free marketplace of ideas where government shouldn't interfere, and the idea is kind of the Enlightenment idea, it's freedom of expression which sorts it out, then it's hard to do a lot about fake news from this paradigm. But I mean, it can evolve as well. So that may be answering the First Amendment issue.
And maybe I can supplement that. This is something we've thought a lot about, and two major points. One is there's a lot that can be done through how we regulate process as opposed to content. And this goes back to the points that you've been making about data overall. So that means that we don't have nearly enough information about what decisions are being made according to what standards in terms of the existing systems. We also need, better remedies. So, more transparency around when something is taken down, why it's being taken down, more immediate access to be able to appeal it and to get it put back in place. So there's a lot that can be done around process to address some of the problems that we see with disinformation and hate speech and other things on the web. On the other side, it's often framed as this dilemma about, is it, do you let free expression, or do you encourage the other, a more comprehensive approach to allowing more regulation of speech on social media? And the reality is, freedom of expression is not the only right at issue here. So when you have disinformation about, voting places, that's interfering with somebody's right to participate in a democratic election. When you have fake information about health, that interferes with their right to health. So we do have responsibilities to look at the full ecosystem of rights and make sure that we have enough space for approaches to be taken that take into account the full panoply of rights that are at stake. And one of the encouraging things we've seen, of course, is that the toolbox is not simply leave it up or take it down. There are so many different ways in which speech can be addressed, and in fact, that whole virality effect of being able to transmit fake information is one of the most effective things. That if fake information gets posted but just stays there to the small group of people it's often posted to, then we don't have as big a problem. It's the virality that is often the biggest issue. And for example, WhatsApp took substantial steps to limit the size of groups and the ability of information to spread, and it can be more effective. And of course, we've seen the approach that's been taken in the U.S. With regards to disinformation of, disclaimers, linking to additional information that's actually factually correct, and other approaches like that can have an impact as well.
Thank you very much. As the time is up, I need to conclude very, very soon. This discussion about disinformation and fake news is a perfect way of announcing the next conference of 16th of December, which will be exactly about disinformation and democracy. So stay tuned, we will be happy to have you again. Difficult to conclude now for such a broad topic. Nevertheless, thanks to you, thanks to our speakers, thanks to our students with their questions and Slido, we found some lines of thoughts for new solutions, in particular at the citizens' individual level. Paul-Olivier Dehaye mentioned, for instance, the possible approach of having codes of conduct, also individual access requests at the collective level. For the digital governance, we understand that Geneva may remain an interesting or important ecosystem and place to monitor and to develop digital governance, in particular for our privacy rights. To close this conference, I want to thank everyone who made possible this conference despite the restrictions, our team at the Digital Transformation Office, the IT and the communication team, and of course all the experts, either remotely or here on site. Thanks really very much for your participation and for all your thought and line of ideas. So stay tuned. I hope and look forward to seeing you for next conferences.